per Joe Tyson's request, who is a friend of the channel and has contributed to the channel financially in the past. So thank you, Joe Tyson. If you contribute, I may cover your story. No guarantees, because I have passed on requests to cover stories before as well. But I thought this was an interesting story, so I'm going to cover it, and we're going to read it and get started. The Constitution's ban on cruel and unusual punishment is in grave danger from the U.S. Supreme Court. With Kennedy gone, the Supreme Court already rethinking the Eighth Amendment. So I do take immediate note that Vox has colored the argument already. They're saying that it's in grave danger. So the idea of what cruel and unusual punishment means or should mean is obviously potentially a very nuanced and complicated discussion. To say that's in grave danger suggests that the court isn't taking it seriously. I don't think that's fair. I think they are taking it seriously. The question, as always, is what constitutes cruel and unusual? When the founders wrote this clause, I think they most definitely meant to include some very, very nasty forms of capital punishment that were done in the past. There are some ones that are not particularly well known, where there are some real things that are very cruel and unusual. I'm not going to give any examples here so that we all save our appetites a little bit, but some of the things that people did in terms of capital punishment in the past are really, really brutal. Unbelievably brutal. So, even in the United States, we have never done anything that even begins to compare to some of the forms of capital punishment that were used in antiquity. So let's just keep a matter of perspective as we're discussing this. That doesn't mean that things that are done in the United States are not cruel and unusual. Don't misunderstand me. I'm not saying there aren't forms of cruel and unusual punishment. I am saying, however, that nothing we've ever done comes close to some of the things that were done in antiquity. So let's keep things in perspective as we're reading and learning. There probably isn't much doubt how the Malvo case, a case that Supreme Court will hear on Wednesday, will wind up being resolved. We covered that case. We live reacted to it, as a matter of fact. So you can go watch the video from that previously. The Malvo case is Lee Boyd Malvo, one of the famous the serial killers from the snipers. He was 17 at the time of the rampage. There's not much doubt that the court will deny life without parole. I think so. But in the likely event that Malvo loses, although I think it's more likely that he'll win, not that it will matter, matters a great deal how he loses. The claim was that it was sentenced in violation to cruel and unusual punishment. The Supreme Court signaled a few months ago that wants to dramatically roll back the scope of the amendment. Okay, I take exception to the way this is being characterized. They don't want to roll back the scope of the amendment. The amendment means what the amendment means. The question is the proper interpretation of the amendment. So I don't think saying roll back the scope of the amendment is the right frame. So I take exception to how that's characterized. Last April, in Buckley v. Prithlius, the Supreme Court signaled its plan of how it understands the Eighth Amendment. Malvo is the first Eighth Amendment case since that case, so it offers a window into how the court wants to shape the bizarre and excessive punishment. It's not bizarre and excessive. It's cruel and unusual. When we're talking about the Constitution, let's use the correct phrasing. We don't want to ship of Theseus this. It's cruel, unusual, not bizarre, excessive. Malvo could prove to be a filing manner case, which simply states the courts will not apply its decision in Miller versus Alabama, which says the Eighth Amendment forbids a sentencing scheme which mandates life imprisonment without the possibility of parole. Personally, I think they will apply Miller versus Alabama. I think it's going to be a 7-2 decision in favor of Malvo. I just don't think it's going to matter very much in the end. What makes this case significant, however, is the second phase of the doctrinal revolution, and could signal how criminal defendants enjoy far fewer protections than they do under existing law. Bucklew is at once one of the most ghoulish cases and one of the most significant cases. The case involved Bucklew, a death row inmate with a condition which made it difficult for him to be executed. It was some sort of blood dilation condition. Realistic, the case was doomed long before it arrived at the Supreme Court. In Galt v. Gross, the 5-4 held that the death penalty enjoys a kind of super legal status. I object to the categorization of that. That is not a correct or fair characterization. It is not that it enjoys a kind of super legal status. It is that the Constitution itself seems to indicate that executions are lawful by its own terms. If you read the Fifth Amendment or you read the 14th Amendment, it talks about no person shall be deprived of life, liberty, or property without due process of law. Well, what does that imply? It implies that a person can be deprived of life, liberty, or property with due process of law. And we talk about people being deprived of property with due process all the time. We talk about people being deprived of liberty with due process all the time. That would be jail for you. So the Constitution seems to presume that death penalty is an option that can be given with sufficient due process. Now, what exactly that means is, of course, a whole other kind of worms. But Justice Scalia had a very famous saying on this. It's like the Constitution, Eighth Amendment, cruel and unusual clause cannot be written to forbid what the Constitution seems to explicitly allow for, which is capital punishment. Capital punishment is explicitly contemplated in the Fifth Amendment and 14th Amendment. So whatever cruel and unusual punishment might be, it can't be read so broadly as to encompass all capital punishment, because that doesn't make sense. Now, maybe it is the case that there's no such valid way of doing it, but the idea that the death penalty itself is cruel and unusual it doesn't flow from the Constitution's text. It doesn't make sense. In lead up to glossip, several manufacturers of drugs seek to refuse state sale. Yet all 5 of the court's appointees joined the opinion by Alito that suggests the death penalty must be defended against the drug companies that seeks to undercut it. Because it's settled the capital punishment is constitutional, it must necessarily follow as a constitutional means of carrying it out. And fair enough, if you say the death penalty is constitutional, because again, the Fifth Amendment and the 14th Amendment seem to contemplate for it, as long as you give due process, whatever that is, it must be a valid punishment. Then so it's not that it enjoys an extra legal status, it's that the Constitution explicitly allows for it. If an inmate believed a particular method will be painful or even torturous, the burden was on the inmate to propose a different method of execution. So that is a fair statement of the law. It's like, if this method would be cruel and unusual, give us a method that wouldn't fall into that category. Seems reasonable. For whatever it's worth, if I were in this position and asked, I would go with nitrogen asphyxiation, which seems to be by far and away the easiest and least cruel way to go, based on all my understandings of the medical nature of it. And it's foolproof, which is also nice. And the nitrogen, once you're done with it, can be safely vented into the atmosphere, because the atmosphere is 78% nitrogen. So you don't have to worry about the issues that would come with a poison gas. So nitrogen asphyxiation would be my method of choice if I were ever so inclined to have to make a choice. Glossop, however, did not provide much of a theoretical framework to justify its result. It largely began with the premise that death penalty must be allowed. Again, because that seems to be what the Constitution does suggest. Bucklew, which was decided after Kennedy left the court, was the court's first attempt to put some doctrinal heft into it. But the theory of the Eighth Amendment is at odds with the case of settled law. Recall the Eighth Amendment prohibits cruel and unusual punishments. In a seminal opinion, Chief Justice Warren argued the amendment bans punishments that defy evolving standards of decency. Okay. Thus, a particular form of punishment grows more unusual, it grows more constitutionally suspect. Okay, fine. If taken seriously, Warren's framework is an existential threat to the death penalty itself, which is exactly why, in the view of the conservatives, it cannot be taken to its limits. Because it can't be that it should be viewed as an existential threat. The conservatives say that the Fifth Amendment to the Constitution and the 14th Amendment to the Constitution say no person shall be deprived of life, liberty, or property without due process of law, which says, therefore, that a person can be deprived of life, liberty, or property with due process of law. What that should encompass is a whole other issue, but the idea that the death penalty itself is unconstitutional does not flow. It can't be the case the Eighth Amendment contemplates banning the death penalty because the Fifth Amendment explicitly seems to allow for it. Rather than follow Warren's reasoning to its endpoint, because a conservative wouldn't follow its reasoning to its endpoint because it doesn't make sense to a conservative for all the reasons I just said, Justice Neil Gorsuch's majority opinion in Bucklew simply ignores the evolving standards of decency framework. Instead, it suggests the Eighth Amendment was defined in the 18th century and may never change, which, again, is a reasonable line of interpretation for a conservative. Conservatives, when they look at text, they look at what things meant at the time. So when the Constitution was written, what did the Eighth Amendment mean? Or what did it mean when the 14th Amendment got passed because of incorporation doctrine? So what did the Eighth Amendment mean in 1790, or what did the 14th Amendment mean in 1860? These are the relevant questions that you ask. So what was cruel and unusual at that time? We have discussed that a little bit off stream, some of the things that would qualify as cruel and unusual. You can do your own research because I don't want to put it on the video on demand, but there are definitely some things that in 1860 would be viewed as cruel and unusual. And he's saying, look, it's not an evolving standard. It means what it meant then. That's typically the way conservatives interpret law. Yes. Death was the standard penalty for all serious crime at the time of the founding. Yes. In fact, the term felony and capital crimes were one and the same at one period in time. All felonies were capital crimes. So yeah, it was a standard penalty for all the serious crimes. That's true. Nor did a later addition of the Eighth Amendment outlaw the practice. On the contrary, the Fifth Amendment, at the same time as the Eighth, expressly contemplates that you may be tried. Exactly. Because the Fifth Amendment and Eighth Amendment were written at the exact same time, passed at the exact same time, it would be illogical to read the Eighth Amendment in a way that would contradict the Fifth Amendment. That doesn't make sense. You have to read them in the same universe. So if the Fifth Amendment says the death penalty is okay, it can't be the case the Eighth Amendment says the death penalty is not okay. That wouldn't make sense. Gorsuch does list some methods of execution: dragging the prisoner to a place of execution, disemboweling, quartering, public dissection, and burning alive, that violate the Eighth Amendment. I agree. Those would be in violation at the time. What sets these punishments aside is by the time of the founding, they've long found out of use and been unusual. Yeah, that makes sense from a conservative proposition. Bucklew did not explicitly overrule the evolving standards of decency, but it's impossible to square the framework with Warren's. And fair enough. To a conservative, Warren's framework is ultimately wrong. It can't be taken to its limit. Even if you think Warren is right, it can't be taken to its limit, because if you took it to its limit, it would contradict the constitutional text. So even if you think Warren is right, it has to have some sort of limiting principle, at least as far as the conservatives would be concerned. So that makes complete sense. You shouldn't be able to square the frameworks. They're not squareable. Ultimately, Warren's framework would have to bow to Gorsuch's framework. That's the only way it would make sense to a conservative. If the court follows Gorsuch's new test to the logical extreme, the consequences would be dire for criminal defendants. I don't know that that's fair characterization, but okay. Though Kennedy joined the opinion in Gauls, the former swing justice frequently voted with liberal colleagues in expressly harsh punishments. That's true. Gorsuch does vote a lot with left-leaning people. He's much more libertarian in nature, and he's much more skeptical of the government in general than, say, for example, Kavanaugh. So that makes sense. He's more libertarian in nature. So he will find a lot of common ground with left-leaning people on libertarian issues, freedom-based issues. Thus, in Atkins v. Virginia, Kennedy joined the opinion holding the death penalty could not apply to intellectually disabled offenders. He reached a similar conclusion in Roper, which held it inapplicable to people under the age of 18. And in Miller v. Alabama, he joined a decision holding the Eighth Amendment forbids a sentencing scheme that mandates life imprisonment without the possibility of parole. So that makes sense. I just want to see if there's any comments I want to respond to midstream. So that's why I'm taking a pause here. Doesn't the death penalty explicitly cause for treason, death penalty in the case of treason? I don't believe so. It defines the crime of treason, but I don't believe the Constitution says what the penalty for treason is. But let's look it up. Why guess when we can look, right? So let's see if I'm right. Let's see if my memory of the Constitution is as sharp as I think it is. Because I don't believe it explicitly calls for a death penalty in the case of treason. It says what it is in terms of definition, but doesn't say a punishment. So we've got a definition of treason. Treason against the United States comprises levying war or adhering to enemies, giving them aid or comfort, and you need two witnesses of the same overt act or confession. They have the power to declare punishment for treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. So it does set a limit for the punishment of treason. Forfeiture of blood basically means we're also going to say your descendants are guilty. So corruption of blood is saying because you're guilty of treason, your descendants are also guilty of treason. This would be something North Korea does. This is something the Constitution explicitly forbids. You can't do that. And it also says it cannot extend beyond forfeiture except during the life of the person to whom it's applied. So any forfeiture only applies to that individual in their life. So it sets out a limit. So thank God for that, but it doesn't define it beyond that, I don't believe. So there's a extradition clause, which we don't care about. Yeah. So that's all there is. The Constitution doesn't set out a punishment. It just sets out a limit for punishment. So that's totally logical. You can't look things up. Having facts is just wrong. At least not until specifically joining in your Treason facts. Yeah. Heaven forbid we look it up and see what it actually says. Let's guess what it says. Man. Only justifiable death penalties visiting tell us far. I get the reference. Very funny. All three of these opinions, however, rested on evolving standards of decency, and thus could be potentially on the chopping block. Potentially, that's correct. To the extent that the death penalty was valid against juveniles at the time of the founding, you can make a credible argument those cases were wrong. I don't think the conservatives are necessarily in a rush to overturn those decisions, but from conservative principles, they would seem to be. That would seem to not flow. But they're precedent now, and there's no particularly strong reason to overturn them if you don't have to. So I don't think they're in a rush to undo those decisions. And, I don't think they're in a rush to overdo Roper, for example, dealing with juvenile death penalty. Even if you say it was valid at the time of founding, which I think it is, and therefore if Warren was wrong or Roper was wrong, I don't think you would re-examine it just for the hell of it. So I think it's probably safe. Which brings us back to Malvo. Malvo, who was 17 during the 2002 sniping rampage, argues for a broad reading. Under the reading of the decision, Miller not only requires the senators be permitted to consider youth, but actually they also doom so. I think that's a fair reading of Miller, that they actually do have to consider it. Again, if they did consider it, I don't think it makes any difference. But yeah, sure, you have to consider it. Fine, that's a fair reading of Miller. I agree. The state, for its part, also agrees Miller only forbids mandatory schemes. Yeah, we discussed that. I don't think that's what the case of Miller says. I don't think that's a fair reading of the case. I think the government's wrong. If the Kennedy were still in the case, the argument might still have a shot, but it's unlikely to prevail in the current course. The best criminal justice reformers can realistically hope for is a decision rejecting the reading of Malvo and embracing the states. I don't particularly agree with that. I think that the most likely outcome is Malvo wins 7-2, because I think that, yeah, you have to consider it. I just don't think it's going to make any real difference in the end. I think the government's argument is wrong. And I think the conservatives would say, in light of the precedent, it's wrong. And there's no particular reason to overturn the precedent here. So my best guess is that the case is going to be affirmed 7-2, assuming they get to the merits, which is a big assumption because there's a lot of ways for them to duck the question. But if they get to the merits, I think Malvo is going to win 7-2. But I could be wrong. We'll find out. Malvo, however, could go much further than that. It could potentially apply to Buckley's new framework to overrule Miller. I don't see that happening. It could cast other decisions like Atkins and Roper into grave doubt. I don't see that particularly happening. Malvo, in other words, could tell us whether Buckley was simply a one-off effort to come up with a doctrinal justification for the death penalty. For the conservatives, that's super easy. We don't have to think very hard to come up with a doctrinal justification for the death penalty. It's really easy for the conservatives to come up with a doctrinal justification. All we do is cite the text of the Fifth Amendment and we're done. It's you make this sound like it's difficult. It's not difficult. I can do it in 2 sentences. The Fifth Amendment says that life, liberty, and property shall not be deprived except through due process of law. Therefore, with due process of law, you can be deprived of life, liberty, or property. End of analysis. I just did your doctrinal justification. It was super easy. Super easy, barely an inconvenience. And the revolution is upon us. States could gain broad new powers to impose punishments that are now widely reviewed as cruel and unusual. In a famous lecture, Scalia suggested public flogging was permissible punishment at the time of the framing, though he labeled himself a faint-hearted originalist because he doubted he would uphold an attempt to flog a criminal offender. Flogging is probably a little bit much. I would tend to agree. Indeed, it's doubtful that Gorsuch's view of the Eighth Amendment would prevent such a public infliction of pain. Britain did not abolish whipping until 1948, a fairly convincing sign the punishment was acceptable. Delaware Supreme Court upheld statutes imposing lashes as recently as 1963. The court already upheld that the inmate may be tortured to death, at least in effect, if not necessarily intent. That's not quite what they said, and I object to your characterization of the case. That is not a fair characterization of the case. You are pulling at emotional heartstrings in a way that is disingenuous to the legal reasoning, so I take exception to that. The scope of the Eighth Amendment is now in the hand of judges who believe such punishment is acceptable. I feel like I need to explain this in small, easy-to-understand words to Vox, but I doubt it would do any good. Of course, Gorsuch disagrees with Warren. They're completely different legal philosophies. And even as a conservative, if you agreed with Warren, you wouldn't agree it to the limit. You can't, as a conservative. Even if you think it's right, you wouldn't take it to the limit because it makes no sense taking it to the limit. There's a limiting principle, the Fifth Amendment. The Fifth Amendment has to win at the end of the day. So even if you think Warren's right, there's a limit. The Fifth Amendment has to be. I will also agree with you, Captain Terrific, that there is nothing in the Constitution that prohibits either the Congress or the states from banning the death penalty. That is 100% correct. Just because the Constitution allows for it, the Constitution, as always, sets out a floor, not a ceiling. So the federal government and or states can always extend more rights beyond what's in the constitutional text. So there's nothing stopping Congress or the states from banning the death penalty or banning anything else. So if they think, for example, lethal injection is cruel and unusual in their view, they can absolutely pass a statute that says that. There's nothing stopping them from doing that. The Constitution sets a floor, not a ceiling. So the conservative response to this would be, well, go get a statute passed. And many states they have. Many states have banned the death penalty, and the conservatives would say there's nothing wrong with that. We have no problem with you banning this death penalty. Not an issue. So, yeah. So that is the end of our discussion as it relates to this article from Vox.com. The Constitution's ban on cruel and unusual punishment is in grave danger. Personally, I don't think the Vox is correct. I don't think they're correct on how Malvo is going to be decided. I don't think they're incorrect in the danger. And they are correct that conservatives have exception with Warren because the conservatives don't think Warren was right. They think that the language of the Eighth Amendment means what it meant when it was written, and it meant when it was adopted. So take your pick between 1790 and 1860, because when you talk about incorporation doctrine, as it applies to the states, you normally look to the time of the 14th Amendments being adopted. But either way, it's like it meant what it meant then, and it doesn't mean anything more. Now, some of the cases like Roper would not be valid under that kind of interpretation, and Roper would tend to not hold, but I don't see the conservatives in a rush to overturn Roper. There's no particular reason for them to do it, and I don't see this case going that far. I think that Vox is wrong on the law, big surprise, that I think they're wrong, and I think they're wrong in their interpretation, and I object to the way they characterize these cases. The conservatives think that certain punishments are constitutional because they clearly are, and whatever the Eighth Amendment says in terms of cruel and unusual punishment cannot be read so far as to forbid all capital punishment in the view of conservatives, which I think is the correct interpretation of the Constitution, because the Fifth Amendment and the Eighth Amendment were written at exactly the same time. It's illogical to read the Eighth Amendment as banning what the Fifth Amendment seems to explicitly provide for. So that's all I have to say about that, and we'll see what happens next.